Hi, I'm Joan Farrell, a legal editor at BLR. On June 24, 2013, the U.S. Supreme Court issued two rulings that have significant implications for employers. In University of Texas Southwestern Medical Center v. Nassar, the court held 5-4 that Title VII retaliation claims must be proved according to traditional principles of but-for causation, not the lesser causation standard in the law. The question in Nassar was whether an employee must prove that the only reason an employer retaliated against him was because he engaged in protected activity, like reporting harassment or filing a discrimination charge, or if he needs to prove that the protected activity was simply a contributing factor in the retaliation. Title VII allows an employee alleging discrimination to show only that the employer's unlawful bias was one of the employer's motives, a motivating factor in the decision, even if the employer also had other lawful motives for an employment practice. The Civil Rights Act of 1991 added a new subsection to the end of the Title VII section regarding discrimination, but did not address retaliation, which is in a different section. Also, in 2009, in Gross v. FBL Financial Services, the court decided that the ADA required proof of the but-for causation standard in federal age discrimination cases. The decision was based on the use of the term because in the law's definition as it relates to the cause of discrimination. Title VII's anti-retaliation provision appears in a different section from its anti-discrimination provision. The anti-retaliation provision makes it unlawful for an employer to retaliate because of a certain protected activity. Thus, the Supreme Court concluded that Title VII retaliation claims require proof that retaliation was the but-for cause of an employment action. Some of the court's reasons included: the 1991 Act addresses only race, color, religion, sex, and national origin discrimination, and says nothing about retaliation. Congress inserted the motivating factor provision as a subsection to the discrimination section, not the retaliation section. In a precise, complex, exhaustive statute like Title VII, reference to race, color, creed, sex, or nationality should be treated as a synonym for retaliation. The court disagreed with this argument and said, for example, the ADA, which has an express anti-retaliation provision, was passed the year before the 1991 Act, and showed that if Congress elected to address retaliation in a statutory scheme, it did so clearly. If Congress had wanted to make the motivating factor in the 1991 Act applicable to all Title VII claims, including retaliation, the court said it could have used broader language, or it could have added a provision to a section that applies to all claims. The fact that it didn't indicated its choice. When the court has read a bar on retaliation into a civil rights statute, it said it was because the laws were broad general laws on discrimination, and not precise like the Title VII statute. The dissenting opinion noted that anti-retaliation provisions are tightly bonded to the core prohibition against discrimination and can't be disassociated from it. The anti-retaliation provisions secure anti-discrimination provisions by preventing employers from interfering with an employee's efforts to be protected from discrimination. The dual standard for discrimination and retaliation claims, said the dissent, will make it difficult for jurors and trial courts to distinguish between the two when they're faced with both issues. The dissenting opinion states that the 1991 Act was intended to strengthen Title VII, and that Congress would have used limiting language if it had intended to limit the coverage to discrimination and not retaliation. But it used the phrase, any employment practice. In addition, the dissent noted that the court interpreted the word because in a way that's inconsistent with the interpretation of the same word in the discrimination provision of Title VII, but in a way that's consistent with a different statute, because of the court's prior ruling in Gross. So the employer prevailed in Gross because the ADEA's anti-discrimination language is different from Title VII, and then the employer prevailed in Nassar because the court said there's no meaningful textual difference between the ADA's use of the word because and the use of the same word in Title VII's retaliation provision. So according to the dissent, it's a case of heads the employer wins, tails the employee loses. It asserted that identical phrases appearing in the same statute are supposed to be given consistent meaning, so the same mixed motive standard should apply to both Title VII's retaliation provision and its discrimination provision. In a related video, we discussed the other employer-related case, Vance v. Ball State University, in which the court ruled on the definition of a supervisor for discrimination cases. For BLR, I'm Joan Farrell. Thanks.